Mamuina akwaba edebode ni hutivnetifo Martin Owura Martin Amidu yene nim sebra ssrèak na nadodan kweku fado the office of the special prosecutor eba fofo no and for the first time occupy esa position and afiso asanso abaye attorney general penchese eba law related cases etif wa bin wo mu papa enya asem keto ne sam ne mokase die odinsem bia betodru etifo ano edin pa na enmusu sa ehun na me person ko too into much details. No, she was sitting for the case involving a Unibank, ssrèak John Dramani Mahama. Now, probably any nipa appointing as a attorney general, Dominic Akrotinga Ayine. Say Owura Martin Amidu Chema Papano. He is very, very corrupt. Pana corruption there. A bomb on who papa. Now, Sikama Tafreno. And yasam K20 from Bessemabo era Semnimubi. Na Makoka and Sama and Sameka. Enutira se bipina kono kutie nsema Owura Martin Amidu ankasa kanodi tudwa no chechemu ekwan the attorney general afaso corrupt medamu nyina as
of a plea bargaining agreement pursuant to the Criminal and Other Offences Procedure Amendment Act 2020 Act 1079 or asking the accused to make an offer of compensation or restitution under Section 35 of the Court Act 1993, Act 459, as amended to the court. Risks of high corruption. This wreaking high corruption practice by this government has been dressed in the robe of an exercise of prosecutorial discretion by the Attorney General Dominic Akrotinga Ayine, whose discretion needs no explanation, but who, in the spirit of accountability and transparency, considers it appropriate to provide the public with a rationale behind this decision. Now, the truth of the matter is that the government and its attorney general knew that there was no way they could get away with quietly filing a discontinuance of the trial as they've been doing in such an important and high profile expropriation of public funds by the government's associates and cronies without the discontinuance becoming public and patriotic constitutional advocates asking for answers for such flagrant abuse of power and the warm embracing of corruption. What the government has done through its Attorney General is to sidestep the elaborate procedure set forth under the plea bargaining law and procedure contained in the Criminal and Other Offences Act, Amendment Act 2022, Act 1079, Section 35 of the Court Act, which would have ensured a transparent judicial accountability by the accused persons for the crimes committed against the public. Instead, the government and the Attorney General claimed to have used non-legally binding rules and procedures justified on the basis that, in pursuit of this objective, the Office of the Attorney General, in collaboration with other relevant state agencies, established a threshold of 60% recovery of the alleged losses to the state as a condition for reconsidering prosecution in specific cases. First and foremost, the gratuitous government justification delivered under the small screen of reasons by the Attorney General for the exercise of his prosecutorial discretion in a press release from the Office of the Attorney General dated 22nd of July 2025 consists of empty rhetoric of accountability and transparency in the exercise of discretionary power, directly and patently contrary to the preambular values of true accountability and transparency underpinning the 1992 Constitution. Wow. Martin Ebi Amidu, brofa kese di wonim yusu pa. Na yanto aso. Some of the suspects in the case, particularly the first accused and the recently appointed governor of the Bank of Ghana, who was also an accused person in the same case, when Ссrèak Ayine appeared as the lawyer for Kwabena Duffuor, have been very close political associates of President John Mahama and the Attorney General Ssrèak Ayine for years, and it is a statement of fact. Kwabena Duffuor was the Minister of Finance when John Mahama was the Vice President and later became President after the demise of President Mills between 7 January 2009 to 7 January 2009, to 7 January 2013. Kwabena Duffuor also contested the primaries to be nominated as presidential candidate for the NDC in the 2024 election, only to drop out of the race before the ballot. Johnson Pandit Esiama, who is recently the governor of the Bank of Ghana and was recently appointed by President Mahama, was appointed on 16th April 2016 as the second deputy governor of the Bank of Ghana in the first government of the president. Johnson Esiama resigned his office in 2017 to put himself upon the Republic for trial in the case under discussion. Ssrèak Ayine was then Deputy Minister for Justice at the time of Esiama's appointment to the Bank of Ghana. The case against Esiama in the Kwabena Duffuor case was withdrawn from the trial high court upon the instruction of Ssrèak Ayine as John Mahama's Attorney General by a notice of withdrawal filed on the 29th of January 2025 to pave the way for his appointment as the governor of the Bank of Ghana by President Mahama on 31st January 2025. Only to be followed closely by the abuse of power in discontinuing the whole case of Kwabena Duffuor and his cohort of accused persons by nolle prosequi on 22nd July 2025. The foregoing demonstrates that the government represented by the President, John Dramani Mahama, is tainted by conflict of interest under Article 286, with the Attorney General being further tainted with abuse of discretionary power under Article 296 of the 1992 Constitution, in entering a nolle prosequi in the case of the Republic versus Kwabena Duffuor and 7 others on the grounds of a shadow self-serving established 60% threshold for the recovery of the alleged losses to the state as a condition for reconciliation